So it makes me wonder sometimes. I wonder all the time, as a matter of fact. So, Alicia, you've done civil trial work, so you know that it is a slog to get into court, to get out, as they say. By getting out, I mean they hand out a courthouse and a courtroom that you can use. Number one, because criminal cases take precedence, and after COVID, there was a lot of backlog. So here you have a case from 2016. It does see the inside of a courtroom. It's a civil matter, but I'm still wondering how bad things were in terms of attempts to settle that got them into trial. What are your thoughts on that?
I don't know. I must tell you that in Florida, cases did settle. They did get resolved during COVID. Yes, there's a black backlog. The way I explain to clients is it's kind of like being on the runway of an airport. You know, you just got to wait your turn, but you need to be at the airport and be ready to sit in your seat so that you can go down the airway. But many of the judges even now have backlogs of about 1,400 cases. They will get through. But saying that, one of the other things I realized in this particular case is that a proposal for settlement was not filed. And the proposal for settlement doesn't have to be filed, but it is a really useful tool to use to try to resolve litigation. And if you believe that you're going to be victorious because you have the damages, the money damages that you believe that you can prove, then there's good reason to file your proposal for settlement. In this case, and I went back to look at the docket to see was that filed, and I did not see the proposal for settlement filed by either party. And so when the judge then said, okay, prepare for me the judgment, the order of judgment in favor of the defense and reserve costs, he didn't say costs and fees. And I think that there's much to be learned from this case. Of course, we are all sitting here playing, as you said, Tuesday night quarterback, because Monday night you do play football too, but Tuesday night quarterback, and the makeup of the jury, and that's something I know nothing. I don't know who was on the jury or their background, so what information they gave in response. But whether or not someone is fearful of animals, whether they're pet owners, all of that matters. But even us pet owners, and I'm going to say us because I am a rescuer, I'm a pet owner, um, are just we're reasonable. I mean, we understand the safety precautions. In this case, it really did seem that Candy was fine. If you kick a dog in the head, he wants to. Hell, I want to bite you. I mean, really. I. But I think that the jury considered more than just the actions of the defendant. I think they looked at the totality of the information that they were given to make a decision.
Yeah.
And they did it.
And you're right about this is one of these cases where if they bring it to my firm, and okay, your guy shot a dog. Okay, do we have a junior associate somewhere that would like to take this? Because right out of the box, this is not a case that you think from the defense side. I mean, it's a huge uphill battle to begin with, but they were successful, and Candy the dog did not, I'm sure in the eyes of many, get justice. It's important to point out, you mentioned, Celicia, in that judgment, the court is awarding costs, which are normal. That's not attorney's fees. You don't get those unless by statute or by contract. So this is not a big windfall for defense counsel either. So.